4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 5532 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
And welcome to the studio, welcome to the microphone, Andrew Bell from Bell and Senior Lawyers.
Thanks once again, Colin. Great to be back.
Well, we had a discussion after last week, and we're discussing the number one questions that come through your website, walk through the front door. And after 20-odd episodes, 23, I think you mentioned, the number one questions goes back to wills, probate, and family provision claims. So we thought we'd just go into a little bit more depth today and try and cover that one off. If it's still the number one question walking through the door, it must be on other people's lips as well.
Absolutely. And I thought what we'd do is we'd talk a little bit about it before we take callers this morning, and focus on the question that everyone has around how can they avoid the problems around what probate is, and also how can they avoid giving things to people that they didn't want to give it to. And I can explain a little bit about the normal advice that I give on the radio and why I give that advice.
Well, that's a common worry, and I can imagine, and the honest answer is more nuanced than people expect.
It is. So we'll go through the specific options that people can consider one at a time, and then talk about why I don't just hand them out as blanket recommendations.
Look, it's interesting because you can, as we've been talking about, go and get a will kit from the post office. But when you're wanting to get down to the nitty-gritty, when you're wanting specific things done, or you've got complex issues, this is the reason why you've got to do it right.
Absolutely. There's lots of reasons that a will can be challenged. It could be invalid and that it wasn't executed properly. It could not consider all the people that it was meant to consider. There might be multiple competing wills. There's all sorts of reasons why, and why it looks very simple what you get written down, and what may have worked in the past all depends on their personal circumstances and who's likely to challenge.
So let's get back to the real basic principle. I write a will. What I write down and what I want post my death should be, in my mind, and this is the logical conclusion, exactly what happens. But that is not the case.
That is not the case. Not in Queensland, not in 2026. Now, this may have been the case some point in the time, but there is, as part of the Estates Act, there is the ability for people who could expect to challenge under the will, under the Succession Act, that spouses, de facto partners, children, stepchildren, grandchildren, dependents, if they would have expected to rely, and they were reliant on your estate, that they could actually put in a claim. And this may be people that you don't like, or you've specifically tried to avoid giving anything to.
All right, let's start with the basics. What's probate?
Okay, so probate sounds scary, but it's not. It is relatively time-consuming, but essentially it's the court formally endorsing that a particular will that's submitted to them is valid, that the executor has legal authority to deal with the estate, and if you don't have probate, banks and land titles, etc., won't release assets.
So this is the formal declaration. You can't just scribble something on a piece of paper. You can't have had 5 wills in your lifetime. This is the one that I agree, or we all agree, is the absolute paramount. I did it last. These are my last intentions. Yes?
Yes. So, well, at least that's what someone takes to the court. They say, I'm the executor named under this will. Here is the circumstances that this will came to be. Here is the original copy of the document. Here is the death certificate we've advertised far and wide to make sure anyone who wants to say this isn't real has the opportunity to challenge it. And the court will then say, well, everything looks valid. This is the will. You are the executor.
Okay, next step. And who can challenge a will, and on what basis?
So as I said before, if it's invalid, if there's incapacity, which is a big one that's coming up, is it presumed that while we do have what looks like a perfectly regular will, did the person understand the decisions that they were making when they made the will? So particularly if someone's entered into a dementia ward, or if there's allegations of undue influence, or if the paperwork isn't complete, those are all reasons that a will could be challenged, as well as I said, those family provision claims, not making adequate provision for people who depend on you financially.
Okay, and who's eligible then to, I've got here for the second type, but you might need to explain that.
Spouses, de facto partners, children, stepchildren, sometimes grandchildren, but it could also be other people that were living with you that you were commonly supporting. Nieces and nephews. You might have someone that you've adopted or semi-adopted that's living with you that you're financially contributing to their welfare. All of those people may have an expectation that would continue after you die. Now, because of those challenge options, people have been ringing into the show on a regular basis, or contacting me, or ringing the office and asking, so what can I do to stop, we'll call him Jimmy, from claiming on my estate?
That's right. So let's say Jimmy has not had anything to do with his parents in a very, very long period of time, hasn't cared, hasn't wanted to. The parents go, well, I've got no relationship. Realistically, those people who I have had a relationship with, they've looked after me, I've looked after them. They're who I want to leave my estate to.
So the first thing that they could do is the simplest. They could just give everything away while they're alive. If there is no estate, at least in Queensland, the law is slightly different in New South Wales. If it's not in your estate when you die, it can't be subject to a family provision claim.
Okay, all right. So obviously just gifting everything away comes with its own set of concerns and worries, but we'll delve into that in a little bit. Who's that suited to?
Well, someone who's confident in their future finances and they trust who they're giving it to completely. They don't need the asset as security for anything later in life. It's not suited to someone who might need aged care funding, who isn't certain the relationship will last, that the person that they've given it to, and there also may be some Centrelink implications for gifting money for the next 5 years after you've gifted it away, that you may still need it for a pension.
Okay, what's next?
Joint ownership. So this is common ways that husbands and wives have often held property over the centuries. With joint tenancy, when one owner dies, the asset automatically passes to the survivor. So this doesn't go through the will or the estate at all. All they need to do is produce a death certificate. So if you don't want the house to go to Jimmy and you're married, or you want someone else on the title, then that might be a convenient way to have it transferred. Again, you need to trust the other person, though, that's on the title, that they don't then try and sell their interest.
So while we're talking about all of these things, to me, this still comes down to specific advice to your circumstances, and I'd say that we need to make sure that everybody does get specific advice on their circumstances, even though we're running through the options, yes?
Absolutely. And this is why normally when people call in, I say, make sure you document your wishes. Make sure it's very clear why you're making the decisions that you're making. Don't make it look like you accidentally left someone out. Don't, if you're giving a provision that's a small amount, and we normally recommend people give a small amount to the people they don't want to inherit, such that it's very clear that your intention was to you didn't overlook them, you carefully considered it. And make sure if there's any questions about medical concerns that you get a letter from your doctor that you have capacity, and get someone to witness the will who can also ask you some questions so they can test your capacity and understanding of the document you're signing. That's the general advice I'm always going to give when someone calls in. But there are all these other options, but I don't know you over the phone for a 2-minute call. And I could say, well, give everything to your son so Jimmy doesn't get it. And that son has a gambling problem, or you were planning on moving into a retirement village. Now you don't have any assets to be able to actually purchase that unit. There's a lot of considerations that need to be made that we need to interview someone before we'd recommend anything beyond, don't worry about probate. It's not that hard. Your executor can deal with it, or get a lawyer to help them. And if you're giving stuff away, don't do a complex trust or give things or other bits and pieces without actually speaking to people who do this for a living.
All right, we might go to a word from our sponsor and then continue the discussion on wills, probate and family provision claims.
Retirement, property decisions, family changes, life after 50 brings important moments. Our trusted sponsors, Bell & Senior Lawyers, would love to help you with estate planning, family law and property conveyancing, offering straightforward advice you can rely on. For expert legal support with a personal touch, call Bell & Senior Lawyers on 07 55 32 8777 or visit bellsenior.com.au.
All right, we are talking legal matters this morning with Andrew Bell from Bell & Senior Lawyers. The discussion has been wills, probate and family provision claims. It is now time for you to get a little bit of free legal advice. If you'd like to call in right now on 0755 208888, and Andrew will be very happy to answer your questions live on air. Now, continuing that discussion, superannuation comes up a lot too.
Absolutely it does. So super, we've touched on briefly in previous episodes, doesn't actually form part of the estate typically. You can do something called a binding death nomination, and the trustee of the super fund can actually give the money for all whatever's held in super to the people that you've nominated, bypassing your estate. Also, anyone can call in. It doesn't have to be about wills and estates.
Correct. That's a good point. If you've got a question, anything that's legally orientated, we'd be happy to answer it for you today. All right, 0755 208888. Now, trusts, we hear that term thrown around constantly, but I'll leave it to you to explain the nuances.
Okay, so there are two types of trusts when we're dealing with estates that are often confused. So there's something called a discretionary trust, and that's set up when you're alive. And the trustee decides how the income and assets get distributed amongst what's called a beneficiary. And this is common for asset protection, family farms, that sort of thing. And then you have a testamentary trust, and that's a trust that's written into your will and only comes into existence when you die, holding assets for beneficiaries rather than giving them the benefit outright. Now, these are excellent if you're worried about marriages breaking down, if you're worried about a beneficiary who can't handle their funds but that you want to help them, because you won't be around, or a beneficiary being too young or vulnerable to manage a lump sum well. A discretionary trust suit people with business interests or investment portfolios who want flexibility. Now, they're complex beasts. They are legally independent of you. They require auditing annually. They require tax being done annually. There are different land tax requirements about who's living in a property. So having a trust set up is a complicated thing to do. Now, it may be right for some people's circumstances, but you need to understand what you're getting yourself into. You need to understand the relationship between the appointment of beneficiaries. You need to make sure that you're compliant with everything going forward, and you need to be happy with the expense. And if you're not doing those things, then a discretionary trust may not be for you. And a testamentary trust, when we're talking about making sure that Jimmy can't get your assets, well, that's created by the will. So therefore, it can be interpreted by the courts if there's a challenge to that will.
Gotcha. Okay. So when it's complicated, it says expensive, and also that there's a lot to maintain.
There is. You're looking at getting professionals to set it up, and you're looking at accountants, etc., engaging with them on at least an annual basis to manage how the benefits have been distributed, and how the assets have been owned. There's capital gains issues. There's a whole lot of things you want to consider.
All right, this is a Talkback program. It is now time for you to give us a call. 0755 208888 is the number. Any legal topic is on the table this morning. We don't have to talk about the interview topic. 0755 208888. All right. What about leaving someone a life interest instead of the asset outright?
Okay, so a life interest can be both something that you give if you own a property, or something that you could give yourself before you transfer a property, or be given for someone else. And it's not something that we hear of. They used to be much more common. But essentially it gives someone the right to remain on a property for the rest of their life. Now, typically this would be where the property isn't mortgaged, so it can't be sold. So you may decide to give your property to your child who's not Jimmy, and that child promises that you can live there for your benefit for the rest of your life. And then when you die, well, again, you don't own the asset, so you can't give the house away and Jimmy can't get his hands on it. But we have problems with this one too. Everything has pros and cons. Again, because you don't own the asset, what happens if it's not maintained? Who's responsible for maintaining it?
Gotcha.
What happens if you need to go into a care home or something else, and again, you need to borrow money? It's no longer your property. And if you leave, you may not have any rights to go back. So you need to be very certain that the property that you've given yourself a life interest in is suitable for you for the rest of your life, taking into account all of the contingencies, and that you have enough money to be able to manage it as well. So that may suit some families. Some families are very confident living generation to generation in the one place. And again, this is something that's often done with farms, etc., to make sure the farm isn't diluted amongst every child. But again, I wouldn't recommend just as straight advice, go give yourself a life interest and then give the house away, because in 10 years' time, this might be one of the worst decisions you've ever made.
And that's a good point. And just preying upon the experiences that we've had here with our volunteer base, you just don't know what's in your future. There could be a surprise illness, there could be some sort of catastrophic event, all of those types of things, and you need access to money fast. Now, you've just got a life interest. That's what you're saying there, Andrew. There you go. All right, 0755 208888 is the number to call if you'd like a little bit of free legal advice this morning on the show. I know the topic is a great topic, and I'm sure you're listening and enjoying it. We'll continue that discussion, but please bear in mind, if you've got a question, we'd love to hear from you. All right, documentation generally, statements of reason and so on. There's lots involved.
There is. So we're talking about, can you do a will yourself? Yes, you can. You can buy a will kit online and do it. Some people have days where you can come in and do a will. And a lot of people will say, well, it's not that hard. Everything looks pretty straightforward on paper. What's on paper may be straightforward, but it needs to be checked that it is actually according to your circumstances. So when the wills get challenged, often one of the reasons is because it wasn't done properly. You've got to have, for example, you can't online witness a will. We can online witness affidavits and all sorts of documents in Queensland now. A will and a power of attorney, you need to have everyone who's witnessing in it in the same room to do it. And they need to be people who aren't inheriting from the will. So if you're doing your own will and the two of your three children witness the will, well, they've just written themselves out of the will by witnessing it. If we've got multiple copies of a will, how are we documenting what those previous generations of the will were? Have we declared that this is the current and you intend on destroying the previous will, or is this read together at the same time as the will? If we've destroyed a will, where is it? And we mentioned the capacity question earlier. It needs to be very clear to survive being challenged that the person who made the will understood the intention and the outcomes of what that they were actually doing with that. So if there's any question around your capacity to make those decisions and they're not documented anywhere, then even though you did understand it at the time, if it's not documented properly, it could be really subject to challenge.
There you go. Well, we have our first caller, and we will say a very good morning to Suzanne. Suzanne, ask your question of Andrew.
Yes, good morning.
Morning.
My sister recently passed away. We know that she had made a will last year, but we don't know who she made that will with. How do we find out and get a copy?
Okay, now there are some services, if you Google Lost Will, that will actually send emails to lawyers. You can also advertise it in the paper. I would start by also emailing the public trustee. They're often aware of wills or where it may come from. But there is no central register of wills in Queensland. Otherwise, I'd probably be looking through her phone records and using... I would take a copy of her phone records and put them into AI and see if any of them match up to a call to a lawyer, and then call the lawyer that she might have called. But there isn't...
She was in hospital for a while, and when she died in hospital, and they said they couldn't find her phone. So we don't have her phone with us as well. There's a bit of a problem there.
Look, one of the things I have seen in the past is solicitors, PAs and so forth, travelling through the paper to see births, deaths and marriages and looking for anyone that maybe have passed away that they hold a will for.
Now, if there is no will, then she could be deemed as being what they call intestate, and someone can apply for guardianship. They can apply to the court to be the administrator of the estate, and then there are rules of intestacy that would apply as to how any gifts that she would have given would be handed out, and that works very similar to probate. And normally there is a provision for their partner, and then for children in equal shares, and then parents, and then others in a series of cascading things. So if you can't find a will, it doesn't mean the estate can't be distributed, but it may not meet her wishes when that happens.
Okay, so can anyone request for a copy of the will?
Well, they can. Anyone who can expect to inherit under a will can request from the person holding the will for a copy of it, particularly after the person has died, but not beforehand. So you would be free to write to lawyers and say, do you hold a copy of this person's will because she has died and we're looking at distributing the estate, and they should tell you whether they have it or not.
So if I Google lost will, something should come up?
There are some services that then do email blasts around people who are likely to have the will. I'm not sure if there's a fee involved, but I do get the emails come through the door from time to time from those sorts of services.
Okay, beautiful. Thank you so much for your help.
Thank you.
Thank you for your question, Susan. All right, if you'd like to pose a question to Andrew Bell from Bell and Senior Lawyers, now is the time to call. 0755 208888 is the number. 5 minutes left in the program. Head to that phone right now. Okay, so why none of this is general advice is the topic I've got next, Andrew.
Yeah, so we kind of touched on this previously, but we can rapid fire go through some of the options I've given you to avoid Jimmy getting the estate. And talk about why it's not general advice and why you need to go through it with someone.
Sure.
So, first of all, was cost and compliance for the trusts, legal fees, valuations, stamp duty, capital gains tax. You get it wrong, now you've got problems with the ATO, and you may be worse off than just giving Jimmy something out of the will. Then we've got Centrelink. Again, if you're on the pension, depending on how you've gifted assets or holding assets or declaring beneficiaries of trusts, they may actually interfere with your ability to claim a pension and for a significant period of time. Gifting, again, there are allowable thresholds. Borrowing is a question that people often don't consider, but if you're asset rich but cash poor, you may want to involved in some sort of financing option secured against your assets so you can live in the last few years of your life without having to, impose yourself on family. Well, if you don't have any assets because you've structured them for when you're gone, no one may lend you any money, and you may find yourself without being able to sell anything and without being able to borrow anything.
Yes, look, there's some terrible stories surrounding that scenario. We've got our final caller, I suppose, at this late stage. It's a very good morning to Ray. Ray, ask your question of Andrew.
Good morning. Good morning, Andrew.
Morning, Ray.
Thanks for answering the call. Andrew, I just have a concern. I've had a long-term maintenance program at the same business for years with my car, and last time I had it serviced, there's been a dispute going on, and just wanted some advice.
Can you give me some more specifics around the dispute?
Yeah, look, I've been having the car serviced at the same place for about 7 or 8 years. I have complete service records, and last service there was an error made and it cost me $1,000 to have it fixed. And they're disputing that they made an error at their end.
Okay, well, if you wanted to legally resolve this, you could do a consumer trader dispute through QCAT. Which is one of the minor civil debt options. For $1,000, I think there's a filing fee, and you can also apply for hardship if you don't want to do that. You would then put in your case for why you believe that they didn't use appropriate skill and attention towards fixing your car and why they owe the debt, and they would need to turn up and provide evidence as to why your claim is incorrect. And if they don't turn up or can't persuade the member, you'd get an order for the amount of money that you were overcharged.
Okay, that'd be good. So I go to QCAT, do I?
Yeah, if you go to QCAT, go to the website, look for Consumer Trader Dispute.
Okay, I'll do that. Thank you so much for your assistance. I appreciate it.
Good on you, Ray. All right. Well, Andrew, we're in the final moments of the show. We've got about a minute and a half to go. A summary or some final words?
I'll just wrap up some of the other points that you might want to consider before doing anything too radical with your assets before you die. One is change of mind. What happens once you've given stuff away or put in all these very extreme things to avoid giving stuff to Jimmy? Well, maybe you reconcile with Jimmy. Maybe the person that you did trust, you no longer trust, or they have an alcohol problem or get divorced or something else.
A family problem, yes.
Well, you can't wind it back once you've gone through all of these extremes, or it's very difficult to do so. And another thing is living longer than expected. So you may have enough funds for 10 years, but if you live for 20 years more, you may find yourself that you can't look after yourself. So this is, again, why there isn't one safest option for everyone. This is why my advice is document well, use a professional for a will, make sure your reasons are clearly documented, and don't worry too much about probate or these other things unless you have some very specific circumstances and you're aware of the risks of going down them.
Look, I like the idea of it's a final double check. You might walk into a solicitor's office and say, this is what I want to do. Running through all of the options and then talking about the pros and cons of each one in a final test. There may not be something you've considered is just good governance in anyone's form. So to me, that's the logical conclusion.
Absolutely, and it's expensive when these things are challenged. Your wishes may not be reflected, so it's a small bit for peace of mind of what's going to come forward.
Great information, great show this morning, Andrew. Thank you all very much who called in, Susan and Ray. And Andrew Bell joins us every Tuesday morning at 9 o'clock, and we look forward to your company again next week.
Can't be back next week. We'll resume talking about family law stuff.
Thank you.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 5532 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.